Do I really gotta keep wearing this thing? My papa's got one, but you know, that's on account of the emphysema. Yeah, this is hot, but it's like a dry heat, you know? Now, you ever been to Central Florida in August? Cause, whoo, buddy, it's not really the heat, it's the humidity that'll get you. So what kind of spice are we talking about in here? Like Tony Chachere's? Cause I'd fight a war for that. I think I got it. I just want you to check my moves, okay? You ready? Heel, toe, do-si-do. Come on, baby, let's go sand walking. Yeah? Still too much. Oh, yeah, here comes the sandworm. I know we're trying to limit like our water intake out here, but hear me out. Oh yeah, we don't have ice, do we? Well, you can't drink tea without ice. So you're saying only the Bene Gesserit can do the silence voice, okay? On my planet, that is just known as a Southern mama. Like half the population can do it. So this suit here just traps all my moisture and holds it in place. Okay. Well, where I'm from, we call that swamp ass, except you don't want to drink that water. Is there a trick to get this thing to stay in here? I can't. There it is. Oh, that does sound like a dangerous mission. Who'd y'all send out there? Duncan, Idaho? No, I'm sure he's more than capable. I just on a big solo mission like that, I would have sent, you know, maybe like Duncan, Florida Panhandle. He's a wild card, but he will get the job done, that's for sure. Hey, what do they keep calling him? The Muad'Dib? What does that mean? Messiah? Okay, nah. You ever seen him walk on water? Oh, you ain't never seen water. Okay, touche. Y'all hold on to your little nose pieces here, because I got something that's gonna knock your socks off. Okay, it is also a mysterious blue liquid that will give you hallucinations and kill you. Right here, baby. Mad Dog. Oh, may my knife chip and shatter. Well, my knife came from the Smoky Mountain Knife Outlet. You ever heard of it? So, it's got a lifetime warranty. I saw that guy walk up and put his hands on you, and he could just tell what was wrong with you. That's crazy. Oh, he's a doctor. All the doctors can do that. Oh, wow. For a second there, I thought that was like y'all's version of Benny Hinn. He did a whole crowd one time. My grandma sent him a lot of money. Hold up. Has anybody ever told you that you sound just like Elvis? I'm gonna be honest with y'all. If it weren't for all this spice, this would just be El Paso without the Walmarts. Okay, you take one look over there at Baron von Butterbean and tell me they ain't got Little Debbies on his planet. So your Southern people are super religious too. Yeah, I can relate to that. But I will say, based off how skinny all y'all are, your potlucks ain't no count. So this is a popcorn bucket. I believe you. Whatever it is, you know, I'm sure it will get banned in the state of Alabama. Question here, how does one go about getting one of those shield things? And then follow-up question, does it protect from mosquitoes? I mean, y'all can make a lot of money with spice, but you could make a killing in Louisiana selling those.
Good morning, good morning, good morning. The show is getting started. The song is playing. I found that little clip that we watched in the pre-show earlier, and I thought it was hilarious, so I had to share it. It was even Dune related. I thought that was cool. It was Dune and Southern person related. I can completely identify with all of it. I have not seen that yet, Allie. I have not seen that. And above all things, remember this most important message. If you don't learn anything from the stream today, take that one away. Oh my God, the dogs are on the couch. They're being so good right now. They've literally been barking all morning. I wouldn't be surprised if they decided to put their 2 cents worth at some point. Morning. Happy Saturday morning, everybody. How's it going? I am your Lone Wolf Oosel, and I am here to present a variety of court cases that I hope are going to entertain and be here for all to enjoy. I don't know what to say. I do know, however, that we have some very interesting cases today. We're going to start off with a special cut that I put together from another channel. They're called Truth Science Bay, I believe is the name of the channel. This is going to feature Judge Hayward and a couple of Moorish sovereign citizens. It's actually 2 different hearings kind of put together. And you see the first hearing where the Moor kind of talks to the judge and she kind of lays down the law, and then he comes in with his lawyer in the second hearing, who's actually an attorney general. And he comes packing with some very interesting court tools. I don't even know how to say it. Anyway, next up after that is Judge Fink. She's got a pretty bad dude in front of her. Then we've got a whole section of Judge Vann, a fun section of Judge Vann. I think we're all going to love Judge Vann. And then Judge Karmy from Cowlitz Court has a Karen to wrap everything off. Sorry for the terminology if anybody is averse to the term Karen. She's got a really angry lady in front of her, and that lady just has a lot of things to say, even though she has a lawyer present. So we're going to go ahead and get things started so we can enjoy some of these court cases and not listen to me ramble. As always, this is a viewer's comment. I didn't comment any of these, so we can all comment on them together and all have fun watching this stuff together. So, ladies and gentlemen, I present to you, live from the gallery,
As well as the standard fair use policy, this video is protected under the Treaty of Peace and Friendship, 1787.
Moors are awake. We are taking our place on this planet.
All right, DeMarcus Cantrell Brown.
Your Honor, we were representing him, but we are going to be submitting a withdrawal to you. You should have it shortly.
All right, Mr. Brown, are you represented by somebody else?
Yeah, for the record, I am DeMarcus Bay, the implied surety for DeMarcus Cantrell Brown. And I would like to file a motion in the court for additional 30 days for me to seek counsel.
Okay, so Mr. Bay,
Yes.
AKA Marcus Cantrell Brown, so you're seeking a continuance to get new counsel?
Yes,
Okay, do you have someone in mind, sir?
I have, not right now, I'm seeking counsel.
Okay, so here's the thing. I'm going to give you a continuance for 30 days, or I'm sorry, until January 5th. But by that time, you need to have counsel on board when they come back so that they can talk to the state to determine if there's anything they can work out on your case, or if they need to get all of the information necessary for a trial, if that's what you choose to do. So by January 5th, I will expect that you will have counsel.
Well, I have paperwork on the docket that haven't been rebutted. I have affidavits of truth that haven't been rebutted.
Okay, sir, we don't do affidavits. People have to appear in person because there's a confrontation clause in the United States Constitution that says witnesses, you have the right to confront witnesses in person. So we don't do affidavits, okay? If you have witnesses that are going to present testimony or evidence on your behalf, then you have to have them come to court and be sworn in and testify at that time, okay? So we're not doing any dismissing and all of that stuff. No, sir. When you get your counsel, they'll be able to discuss it with the state, and then y'all can present whatever to the court.
And the accusing deputy must be present too, right?
No.
Okay.
So the people always say that, but here's the thing. The state gets to choose whatever witnesses they wish to bring, just like your side gets to choose whatever witnesses you wish to bring. You can't rely on them to bring the person that you want. So if you want to subpoena someone to appear for trial, then you need to subpoena them. You cannot rely on the state to bring your witness, okay?
Okay, I got you.
All right. Anything else?
And jurisdiction can be challenged at any time, right?
No, sir. Jurisdiction rests with this court because this is where the locus of the incident is.
Well,
Mr. Bay, let me just explain something to you.
Court cannot confer jurisdiction.
Mr. Bay, listen to me.
Okay.
I went to school for 3 years for this. That's full time. If I had gone part time, it would have been 4 or 5 years. And I have been working since, oh Lord, I ain't gonna give my age, but I've been a lawyer and a judge for quite some time. I've been a judge for 10 years as of this year. A lot of times people come before me because they've learned stuff from other people, or they've gone online, or they've read it themselves. But I tell you, it doesn't work the way you think it works. And so there's a set of statutes, cases, procedures, all of those things that we have to learn. In fact, let me show you something.
Well, how do you have?
Wait. You see this book right here? This is just this year's edition of all the stuff that I have to be able to find to figure out what's going on in your case. This is just this year's edition. And I got a book like this that includes evidence and procedure. I got a whole wall of books. So when you come in here challenging jurisdiction and all of this stuff people have taught you, it's not books.
Can I show you my Black Law Dictionary?
No, sir. Because Black's Law, that's a dictionary. That's not the full case. You know, you come in with all of these ideas about how you think the law works, but every lawyer in here has done at least 3 years of law school and trainings, trials, all of those things. So you're not going to change the way we do things. So the best thing to do is to get an attorney who can talk to the state about your case, and then we can get this resolved. Your case is pretty simple. You got traffic offenses.
Well, I still want you to prove on the record that you have subject matter jurisdiction, personal jurisdiction.
I'm not proving anything on the record, sir. I wear the robe. They put me in this position. I've been here 10 years. If I didn't have subject matter jurisdiction, I wouldn't be here.
So you say it's not a difference between public and private for the record. There's no difference.
Sir,
I'm not trying to have Okay, all right.
Thank
January
you.
5th.
Yes, sir.
Okay.
And Mr. Bay / Brown,
Bay.
you've indicated that you wish to have an attorney, so I'm going to rely on the fact that you're going to have an attorney. Don't come back here with the same stuff, and I already told you it's not going to work.
So you telling me United States codes don't work?
No, I'm telling you, you don't know them. So
Oh, I
first
have
of
it
all,
right here.
the United States codes don't work in Georgia because Georgia has its own code, OCGA.
So the meaning of driver is different in Georgia.
Yes,
But
sir.
according to 49
Mr. Bay, Mr. Bay, I'm not doing this with you. Get an attorney.
Okay.
Thank you, sir. You're free to go. We'll see you on January 5th at 11 a.m. All right, Eric Jamal Burnett.
1 week later.
DeMarcus Contrell Brown.
I have interest in that matter. Is the defendant in error free to go?
If the who, what?
Is the defendant in error free to go?
No.
Well, let the record show the defendant in error is ordered to state and participate.
Okay, who is the defendant in error? That's a new one for me.
The all cap name is trust that I am a beneficiary of. My name is not spelled in all capital letters. I have a court order decree saying that.
Okay, Mr. Bay. Mr. Bay, do you have an attorney representing you, sir?
Attorney General, my Attorney General is online. You may speak to me, sir.
Is the Attorney General, Mr. Bay, hold on, let me ask my question before you tell me something crazy. Is the Attorney General a member of the State Bar of Georgia?
I'm a non-state actor. I'm a foreign national. Matter of fact, I filed
Sir, Mr. Bay.
oath of office.
Mr. Bay, I don't care if you were Alexander Putin, the premier of Russia. If you are in Georgia and you're represented by an attorney, that attorney would have to be a member of the State Bar of Georgia. Foreign national or not. Just as if you went to another country and you had an attorney represent you, that attorney would have to meet the requirements of that country and of that state, okay? Mr. Attorney, Mr. Bay, hush. Mr. Attorney General.
I'm trying to set a record.
Mr. Bay, Mr. Attorney General, are you a member of the State Bar of Georgia? You want to unmute for me?
Speak, bro. Get off mute.
What's going on is he's a member of a foreign state corporation basically doing business in Georgia. So
Okay,
basically,
sir, that's not what I asked you. No, sir.
I get what you're saying,
No, sir.
man.
No, and I get what you're saying, but we're not doing that because that's not how we operate. Those are not the laws under which I am required to conduct court. So we either gonna do it my way or we're gonna put you on the calendar.
We understand the rules of the court. I got you.
Okay, are you a member of the State Bar of Georgia?
No, I'm not a member of the Bar of Georgia.
Okay,
what I'm trying to
then as
he
can represent himself,
you need to take consideration on that matter on how he's doing business in Georgia.
He can represent himself, or he can be represented by a member of the State Bar of Georgia, but he cannot have you represent him or purport to represent him, okay? That's not gonna work. All right. So, Mr. Bay, do you wish to choose someone who is a member of the State Bar of Georgia to represent you, or do you wish to represent yourself?
I invoke my right to remain silent as the beneficiary of Demarcus Cottrell Brown estate.
Okay, sir. So, sir, you're invoking your right to remain silent, which means that you do not wish to enter a plea that
I
would,
plead to be released.
that would resolve your case today. As such, the court is going to enter a plea of not guilty for you.
I object.
put
You cannot
on-
practice law from the bench.
and
Violate
put you on
28
a-
USC 454. Judge practicing law from the bench.
and put you on a trial court, on a trial calendar so that your case may be heard at
I
trial.
object.
All right, sir. Thank you. You'll get notice in the mail. If anything
I
changes
object.
about your, if anything changes about your address, then you can go ahead and let us know by coming
I
into.
have no. I demand an evidence hearing.
You will have that at the time
I
of the
demand an
trial, sir.
evidence hearing.
You're not going to have an evidence hearing today because that's not what we're here for. This is a
You are
regular.
dishonorable. I got your oath, Tammy Long. Hey,
So, Mr. Bay, I'm going to enter a plea of not guilty on your behalf. You'll have a trial at which time you can have an evidence hearing. You'll get notice in the
you
mail.
in
of
violation
that.
of Article 6,
And
Section 2 of the
once you get,
Constitution.
your notice in the mail, then you can appear for hearing with whatever evidence that you wish to
I
present.
object.
Although you are not required to present any evidence or testimony because the state has the right, has the burden of proving the case against you. Thank you, Mr. Brown. You're free to go at this time.
I object.
All right, Kevin Jermaine Burrows. Kevin.
Was that not probably the funniest thing you've seen ever? I mean, really? Those people. Oh, you can't even. You can't make that stuff up. You really can't. Hey, look, we have dogs joining the stream. Woo! All right, next is Judge Fink. Judge Fink's got a bad dude ahead of her. I'm not gonna jam it up. Really don't know that a bunch about it. I watched just a little bit of it. We're gonna watch all of it together. So let's get right to it.
I think it's supposed to be on live stream.
State of Michigan versus Joshua Dye, 24F5 5557. Mr. Dye, could you please state your name for the record?
Joshua Dye.
You may, I will sign the petition requesting a court-appointed lawyer. You may proceed when you're ready. Ms. Vergils.
Thank you, Your Honor. Assistant Public Defender Chelsea Vergils with and on behalf of Joshua Dye. We would waive a formal reading of the complaint, stand mute, and ask to address bond.
Go ahead, Ms. Robbins.
Your Honor, this is based on an incident from March 24th. The allegations in this.
I took the testimony on it. You can say whatever you want to, but I did take the testimony.
Okay. I will try to be brief, but I do want to
Okay. Yep.
note that the allegations are that the defendant shot an unarmed person with no prior connection, no altercation at 2 p.m. on a Sunday at Maine, right downtown, as the individual is getting into the car and attempting to close the door. The detective is here today, and I will ask him to address his concerns about public safety. But I know that he did speak with the victim and the victim's mother yesterday, and the consequences for this victim are severe. Has been in and out of the hospital, 2 surgeries. These charges are obviously very significant. In terms of his criminal history, it also supports the concerns about a risk to public safety, a child abuse first conviction from 2009 that involved a 2-year-old child, and the facts of that case are devastating. In 2022, he had an MDOPP that had several weapons charges dismissed. In 2023, breaking and entering conviction, in which he met a woman that day, was subsequently arrested for disorderly, but when released, went to her house, pounded on the door, climbed through a child's window with the young children at home. All of these really highlight our concerns about public safety and support our request for a $1 million surety bond and no contact with Sarah Martin or Robert Edwards. Detective, I'd love for you to fill in a little bit about your concerns and anything that I missed here.
Certainly. I'm happy to do that. Brad Rougeau, I'm a detective with the Ann Arbor Police Department, and I'm here to represent the concerns of the citizens of Ann Arbor and of the police department. I will probably go over some things that Ms. Robbins already mentioned, but I want to make sure that I cover it. I do think that Mr. Dye presents a significant risk to the community were he out and about. As Ms. Robbins mentioned, this was an unprovoked violent incident with a firearm that happened on a Sunday afternoon in downtown Ann Arbor. There were numerous witnesses to this. It was captured on video. Witnesses include a family with young children walking back from the Hands-On Museum. We have no information that these individuals had any prior contact before this date or really even on that date. The victim in this case, the facts will show that he was actually trying to walk away from the situation and get into his car, and he was essentially chased down and stalked and then shot as he was trying to remove himself from this situation. As a result of this, he did sustain serious injuries. He was in the hospital for multiple days, has endured multiple surgeries, and will have a lengthy recovery due to his injuries. Frankly, were it not for the fact that we were within such close proximity to a level 1 trauma center and that officers arrived so quickly, he may not be alive today. Mr. Dye does have a significant criminal history to include juvenile adjudications for assault with intent to do great bodily harm, less than murder or strangulation. 2 of those, 2 convictions for child abuse in the 1st degree. And in order to be convicted of that, it requires that he knowingly or intentionally caused serious physical harm to a child. This was a purposeful act. I did read the report, and as Ms. Robbins indicated, the facts of this case are devastating. He did serve 10 years in the Michigan Department of Correction as a result of that, and he is currently on probation out of the 15th District Court here in Ann Arbor. As far as flight risk, I can't argue that he doesn't have ties to the community. However, I don't know that he has a stable place where he would be. He provided an address to me of the homeless shelter when I spoke with him. However, he has been trespassed from the homeless shelter. So that's not going to be a possibility for him at this point in time. I'm also
that's because of what's already called.
Mr. Dye, you'll have an opportunity.
It's not your time to talk, sir. Go ahead, Detective Rougeau.
I'm sorry. He has been trespassed from the shelter. A previous report that I was also assigned listing Mr. Dye as a witness had indicated that he was an employee of the Delana Center, and the 15th District Court and I think probation were also under that impression. But in speaking with the director of the shelter, I was told that he never has worked there. Also, other addresses provided for Mr. Dye is 555 Towner in Ypsilanti, which is the Department of Health and Human Services building where nobody actually lives. Mr. Dye was apprehended yesterday by the United States Marshal Service, particularly the Detroit Fugitive Apprehension Team, at an address here in Washtenaw County. So, I mean, frankly, if he were to be out and he were to fail to appear to court, we wouldn't have no idea where to go to start looking for him. And that is problematic for me. In speaking with the victim, he has great concerns for his safety were Mr. Dye to be out. He's concerned that he could run into him someplace and maybe be caused harm again, because really we don't know what precipitated this situation, or at least he doesn't know. It's for all of these reasons that I do think a $1 million bond, surety bond, is appropriate in this situation. And thank you for allowing me to address this.
Thank you, Detective Rougeau. Go ahead, Ms. Vergils.
Thank you, Your Honor. So I did speak with my client this morning and informed him of these charges, which are very serious. First, I wanted to address there is a previous or 2 previous child abuse convictions. And again, I wouldn't want to diminish those very serious convictions, but just to point out that they were 15 years ago, I believe. And my client has moved on from that. He is able to have custody of his 3-year-old child, who he doesn't have full custody, but he sees her every weekend. And the child also lives in Ann Arbor. My client informed me that he currently works at a restaurant in Ann Arbor. He had been staying at the Delanus Center, and my client's impression is that he would be able to go back there once this case is resolved. But I think there may be the possibility of him being able to stay at a different shelter. But regardless, he does receive mail at the Towner address. He goes to CMH every other week for therapy. He also drug tests for probation. As you're probably aware, my client is currently on probation, so I would ask for you to set the smallest possible cash bond in this case. My client is homeless, so a $1 million bond, I would argue, is excessive, and something smaller would keep him in custody. And I've spoken to him about not paying the bond set until his probation violation is resolved. We have no objection to any no contact or no go-to order. Thank you, Your Honor.
All right, Mr. Dye, there are two things that the court should consider when setting bond. One is flight risk. That is whether or not the defendant will come back to court. Will the defendant participate in proceedings against him or her? And then the second part is danger to the community. Does the defendant present an ongoing danger to members of the community? Will there be further criminal behavior? I don't know whether you specifically are a flight risk. You have a history of failing to appear in court, and you have a very unstable residency situation now that you can't stay at the shelter. So I think that that's something that the court should be concerned with, is your potential flight risk. And more importantly, though, is the danger to the community. As I said at the beginning of this hearing, I took the testimony from the police officer, from Detective Rougeau, at the time that these charges were authorized against you. And my habit is to ask questions if I think that there's something that I will want to know about at the time that I'm handling the arraignment. And I did ask a few questions, and my understanding of the situation as presented to me is that there was a person perhaps unknown to you who for some reason was involved in peripherally involved in an altercation between you and another person. And when that individual got back in his car to leave the situation, there was a shooting where you are accused of shooting that person while he was sitting in his car. Whether you know that person or not, any shooting by any person who is willing to use a firearm against another person in a situation where their own life is not in danger presents an ongoing danger to the community. That willingness to fire a gun at another person, there's no reason for me to think that won't be limited to this one incident. So I am going to adopt the prosecutor's recommendation. I am adopting the prosecutor's recommendation. The bond is $1 million cash or surety. I understand that means that you can, that you will not be able to leave the jail. I recognize that is what that means for you. Your bond can be addressed as the case proceeds. While you are in bond, you are not to use illegal drugs, purchase or possess any firearms, weapons, or ammunition. No contact with the alleged victims, Sarah Martin and Robert Edwards. Do not go to, I'm not going to put the victim's address on the YouTube. Do not go to the home of Mr. Edwards, and do not go to the Delanus Center. Do not leave the state of Michigan without permission of the court. No criminal behavior, no assaultive behavior. Your court date will be on April 18th. And you are all set with me. When you're ready, you can stand up and walk to the door.
Yeah.
No.
And that was that guy. I'm not going to gem it up. Next is Vann, and it's everything you expect. Let's just get right to it. Vann cattle call, ladies and gentlemen.
No order change.
1, 2, 3, 12.
Good Lord, what are we
15,
doing?
25 on it up.
Miss Fanbro. Ma'am. No order change? Like I can go in numerical order today?
So missing 3 already.
That's so weird. I don't know that we can do this. Can we go in order? Or am I allowed to do that?
You can go anywhere you want to.
Yeah. You sound like my wife. She tells me where to go.
Oh, amen to that.
I
go anywhere I want to. I mean,
I'm so glad my wife doesn't watch these. Y'all don't think I don't talk crap at home. Only known 50 years. We only known each other since preschool. That's horrifying.
yeah, wait, because your dog's not on yet. Okay. Stepping on the red X.
All right, is this Mr. Fair?
Yes, sir, Mr. Vann. How you doing today, sir?
I'm well. How are you?
Well, I'm kind of confused a little bit because I've been locked up since January 16th.
On another charge?
Yes, sir. They got me fleeing, looting, high-speed, reckless on a bicycle.
Excuse me. Well, you're a heck of a bicyclist, aren't you?
I know it. That's what you know what, Mr. Vann, I don't understand. Maybe for a good thing or a good cause. I'm not sure.
Well, the fleeing and eluding statute doesn't require high speed. It's just an
Yes, sir.
aggravator.
That's what my lawyer was puzzling me. And Judge Stevens says, I don't think there's a statute for that. I just think that Bay County just put another no charge on me.
For fleeing and eluding bicycle,
Yeah.
but regardless,
Yes,
you are. Can you make that bond?
No, sir. I've been in here and it's 10 days. I've done served them.
Well, no,
I've been here
you
almost-
haven't served on this, but
Yes,
since
sir.
you're still going to be in jail, right? You're not getting. I mean, this isn't keeping you in jail, is it?
April 22nd.
Oh,
go to
then
court.
you'll be long gone.
Okay.
So what we're going to do is, I'm going to go ahead and sentence you per capias on this case to serve 10 days in the Bay County Jail with credit for 300 with zero, but you can purge
Yes,
out
sir.
a compact for $350, but there's no reason for you to do that if you're going to be in until the 22nd.
Yes, sir. So I'm good. Thank you, sir.
Good luck.
Thank Bay County. They put me on a YouTube channel, they put me on a YouTube channel without my consent, kicking out the back of Herbert's car. And I get a lot of dirty looks in town when I try to get a job, Mr. Vann. And I've been trying to talk to Tommy Ford about this.
Listen.
Yes, sir.
As somebody that might be on YouTube also, I promise you, nobody looks at you any different because of that, because not that many people watch it.
Yes, sir. Okay.
I've been told, but I don't. You get
Yes,
it.
sir.
Nobody,
Yes, sir.
nobody's like to see you.
Yes, sir. Thank you, sir. Thank you, Mr. Vann.
Step to your right and sign where the
Unless I
green light.
yell at you, they're gonna watch you on YouTube.
State your name.
Boys, before the court started driving under the influence, is that a charge now?
Yes.
For winner. Mr. Taylor was leading the pack at 184. His boys has set the new bar as a 256. All right, that's gonna win. There's no way to cover that tomorrow. All right, Ms. Boys, I understand you've been given copies of paperwork and advised of your rights. That's true?
Yes, sir.
Based on your application, if you do qualify for the service of the public defender's office, I'm going to go ahead and appoint the public defender to represent you. Any question about that?
Nothing, sir.
How you feeling, Ms. Boys? You okay?
Yeah, it's my anxiety's really bad right now.
Anxiety's bad. My head would be killing me. Deputy, criminal history?
No history, sir.
Holy cow. Ma'am, you're lucky to be alive, quite frankly. I mean, no, nobody's gonna beat that. All right, ma'am. You live here in Bay County?
Yes, sir.
How long you live here? All right, I'm gonna release you on what's called pretrial release. You and I need to have a discussion tomorrow in arraignments, because we need to get you find you a solution that doesn't involve getting blackout drunk and getting behind the wheel of the car. Pretrial release, you need to report to the pretrial release office after tomorrow. Your court date is April the 5th at 8:30. Good luck, ma'am.
Okay.
I'll see you in the morning.
Except to your right.
No alcohol. Don't drink while you're on. Let me check. Make sure.
State your name, ma'am.
Swab, you're for the court on a fugitive from justice warrant out of the state of Missouri.
Yes, sir.
Okay, here's the problem. Missouri's got a $2,500 bond on the warrant. But you can't post that here. You got to post it in Missouri. Have y'all contacted Missouri?
I have, sir. I'm her mother.
Sans it, become.
I talked Florida attorney this morning, and I talked to bondsman, went to A1 on the way here. But the Missouri ones aren't licensed here. I mean, yeah, and they can't do it. I brought $2,500, I was told by the warrant office, but that's what they told me, that I had to give her to bond out. But what we found out was in the system, the left arm didn't know what the right arm was doing. May 19th of last year, she's been here, a Florida resident for 10 months. She has.
You got permission.
And what?
You got permission to bring.
Oh, yeah. Tammy, I have her name as supervisor. I've been visiting with her and Miss, what's her name?
Peggy Thompson.
Peggy Thompson. That's Bree's probation officer here. For probation, we changed people, place, and things. And we brought her here and had things here.
We brought her here to rehab.
Rehab.
To get her away from the circumstances.
She couldn't walk when I brought her here. And she has done extraordinary. Had we known or had an awareness, we would have found a solution for the warrant before this would have happened. However, what I learned yesterday was May 19th was when the supervisor signed off on her papers. I also learned that May 19th was when Christian County they filed the warrant. It was executed in July. Well, she was a resident of Florida, so we had no awareness.
Okay.
Fast forward on case.net, Judge Carrier, who is presiding in Missouri over this, it says on case.net at the end of May that he rescinded a warrant. And we're just a little confused. I just don't want her hard work. She's involved in her church. She's paying her own bills. She lives in the Oxford house. She has multiple layers of accountability in place, and she's been very successful since she moved here. And then this came up. We were at the jailhouse yesterday by direction of her probation officer here to register in the Florida system. We thought it was a 10-minute visit. And then we go to probation and I take her to work. They took her in custody because this warrant came up, and it was very shocking.
Ms. Fambro.
Yes.
In the past, we haven't accepted out-of-state warrants. Has that changed?
No, sir.
Okay. That's what I was afraid of. So we've got a $2,500 bond, which is more than makeable. But in theory, we're supposed to hold her from Missouri to come get her? Right, I know. You don't have to answer that.
I'm not.
Okay. Take a deep breath. You're fine. You're fine. Have y'all talked to anybody in Missouri?
I hired an attorney.
And what'd they tell you?
He told me that as soon as we got done here, I could bail her out if they had a bond. Nothing can be done until we see the judge here.
Well, yeah.
And
Well,
that,
here, let me give you a suggestion for that.
Talk to me.
Contact the bondsman in Missouri and have them call the bondsman that you talked to here, what they call an interstate bond. That means it can be paid here, but the bondsman in Missouri is going to be responsible for her.
Does that make sense? Because a Florida bondsman isn't going to be good on a Missouri bond. So a Missouri bondsman can work through a Florida bondsman. You pay the money here. The Missouri bondsman would then sign off on the bond in Missouri. Yeah, you're not, but you're not going to be able to do that because we can't take the money. Yeah. If you somebody go down and post the bond in Missouri, she's got to be present. It's a chicken or egg. She needs to be physically present when you surrender her in Missouri.
but then I was gonna take her, so I didn't have to go down to
My
change.
wife
Yeah,
was
but-
instructed to write a letter to the judge, which she
Mhm.
did.
I did.
And they said that they were going to read that and possibly, because it seems like a big mix up, because we got permission before we brought.
No, I understand all that. I understand everything, but what we're trying to do is we're just trying to get it. We're trying to get her out of our jail
Yeah, yeah.
legally
Right.
with a insurance for Missouri.
So the best thing you're saying is for us to contact the Missouri bond.
We're gonna bring her, long story short.
Yeah.
I'm gonna bring her back tomorrow on my docket. I'm gonna see her again tomorrow, okay? So that way she doesn't get lost in the system. Okay, that gives you time to call the attorney in Missouri who can talk to a bondsman in Missouri. And what she's talking about is an interstate bond where a Missouri bondsman contacts a Florida bondsman. You're gonna pay the money to the Florida bondsman here, but the Missouri bondsman then signs off. And here's what we want. We want Missouri to say, we're satisfied, you can release her. We've got assurances that she'll show up in Missouri. Okay, does that make sense?
He said he would file the attorney.
And you can get this done before tomorrow. I'm just bringing her back tomorrow, putting her on my docket so we don't lose her for tracking purposes. Waiting for extradition, which we don't want.
No.
So you're doing a stay, essentially, you're just kind of doing a stay and waiting for this.
She's gonna be buying you 24 hours to do the things that need to be done.
Well, I'm buying you as much time as I can. But you come back tomorrow and hopefully she's gone. Hopefully she gets out tonight. Yeah, hopefully she gets out tonight. Best case scenario, you make 2 phone calls, you go to A1 bonding here or whoever you want to use here. Right, and then she's out. Okay? Worst case scenario, I'll see y'all again tomorrow. Okay, all right. Well, I'm just saying, that's worst case scenario is we come back at this tomorrow and we try to find another way.
What time do you want me here?
Okay. Yeah.
All right.
Yeah, that's worst case scenario. I see y'all again tomorrow. Worst case scenario.
It's at 10:30 in the morning.
Yeah, tomorrow's at 10:30 if she's still there, but
We'll be on it as soon as we walk up.
Can we leave now and start working?
yeah, go. Yeah, absolutely.
Hang in there, babe, I got you. Hang in there.
Step to your right.
Y'all don't have to stay for
Yeah,
the
yeah, come back tomorrow. Here, hold to the right. State your name, ma'am.
Is this Ms. Bays?
Yep.
Ms. Bays, you're fully court charged cruelty toward a child and cruelty toward a child. Do you understand those charges?
Yes.
Understand you've been given copies of paperwork and advised of your rights. Is that true, ma'am?
Yes, sir.
All right. Based on the application, I find that you do qualify. I'm going to go ahead and appoint the public defender representative. So you have an attorney now. Any question about that?
No, sir.
Deputy, criminal history?
Just 3 DWLSRs, 1 in 20, 2 in 21.
All right, on the child abuse bonds, 50,000. Child abuse is 50,000. No contact directly, indirectly, or through a third party alleged victims. Court date is May 16th at 9 o'clock. Good luck now.
Step to your right to the T.
Mr. Braga?
Yes, how you doing? How about you?
Before the court charge of driving under the influence, you understand that charge?
Yes, I'm sorry. I'm the driver today. I'm feel very sick. I drink one bottle to fight a ball.
Okay, hold on.
Don't talk
about
about
your
it.
case. Yeah. Based on your application, I find that you do qualify for the service of the public defender's office. I'm going to appoint a public defender to represent you, so you have an attorney now. He's going to insist that you not talk about the facts of your case.
Please don't talk about it.
Boy, that was very nice of you. Floyd's been caffeinated today. You got coffee today, Floyd?
Sir?
Do you have your coffee today? All right. Deputy, criminal history, Mr. Braga?
DUI in 20, and that's it.
Bond set at 5,000, no alcohol. Court date is tomorrow morning at 8:30.
All right, step to your right, sir. Step over to your right. Next.
Hawaii?
For the next, state your name.
Good evening, sir. My name is Jordan Dawg.
Good afternoon, Mr. Dobbs. My name is Judge Shane Vann. How you doing?
It's good. It's always a blessing to be alive, sir.
Isn't it though? Another
Yes,
day
sir.
above ground. That's all we can ask for, isn't it?
Yes, sir.
Well, Mr. Dobbs, you're before the court charged with resisting officer with violence, possession of oxycodone, possession of psilocybin mushrooms, shrooms, as they like to say in the parlance, I believe.
Yes, sir.
Obstruction of justice without violence, ×2, and disturbing the peace. You understand those charges, sir?
Yes, sir.
Based on the application you filled out, you do not qualify for the service of the public defender's office, but the law recognizes your financial situation may change, in which case you can reapply later. You also have the option of hiring your own attorney or represent yourself. Deputy, criminal history, Mr. Dobbs?
Out of Georgia. 24, possession of a gun or knife during a felony, controlled substance, tamper with evidence. 23, same two with the possession of marijuana.
Bond set 10,000 on the resisting with, 5,000 on oxycodone, 5,000 on the shrooms, 2,500 on each of the resistings, and 1,000 on the disturbing the peace. Your court date is going to be May 16th at 9 o'clock with random UAs. Good luck, sir.
He can hear you. He want to ask you a question.
I do want to say, sir, I just recently enrolled in school and I'm working at the Marriott right now, sir. And I was just asking if you would please, I was just came down there and enjoyed my trip. I was just asking if you would please be lenient enough to give me an OR bond on one of those because they confiscated my money that I had.
All right, I will release you on your own recognizance on the disturbing the peace. Good luck.
Yes, sir.
All right, step to your right to the T. Next. For the next, state your name.
Andrew James Wood.
Mr. Wood, you're fully court charged possession of tramadol, possession less than 20 grams of marijuana, and possession of paraphernalia. Do you understand those charges?
Yes, sir. Not really. I'm confused about the criminal charge, but I mean, I'm not wetting my vehicle I was driving.
Well, that's better than not your pants that you were wearing. Heard that one.
Or not your suit that you were wearing.
All right. Yeah, they found 2 tablets and allegedly a gram of cannabis. That's the allegation. Plus,
Yes, sir.
Yeah.
I smoke cannabis. I mean,
Okay,
I'm pretty sure.
Let's try not to admit to anything else, okay? While we're here.
I'm just an honest man. Try to be.
What? Did he say what I think he said? That's odd. Okay. All right, Mr. Wood. You make too much money to qualify for a public defender, but the law recognizes your financial situation may change so you can reapply later, okay?
Yes, sir. I don't even have a job.
Well, you told somebody you make 1,100 a week.
No, average.
You turn the impressor?
No, sir. I don't make $1,100 a week.
That's
I ain't even really.
Okay, so you don't make any money?
No, I clean condos like every now and then. That's actually where I was pulling into when they pulled me over.
Well, fill out an affidavit how much you currently make. And that way we can determine if you qualify, okay?
Yes, sir.
All right. Deputy, criminal history, Mr. Wood.
BOP 2223, controlled substance in 21, grand theft locally in 22, meth in 21, and some juveniles in 15.
All right. On the tramadol, 5,000. The pot's 1,500. The paraphernalia is 1,000. I'm kind of treating it all as one package deal, so we can get you one number. Okay, $7,500, $750 with the bondsman. Your court date's going to be May 6th with random UAs. Any questions?
Yes. No, sir.
All right, step
good
to your
luck.
right, to the T. Next, step on the X, sir. State your name.
Still logged in. Still logged in.
Mr. Stovall, you're before the court charged introduction of contraband into a detention facility, possession of methamphetamine, possession of paraphernalia, and resisting officer without violence. Do you understand the charges?
No, sir, I do not, sir. I was stopped on the guys that told me that I had a warrant. There was no warrant for me ever, period. These
Why don't you wait and talk to
placed
your
on me-
lawyer about it?
Man, huh?
Why don't you
He
wait?
said, wait
until
and
you
talk
have
to
a-
your lawyer about that.
Okay, well, I'm trying to get out of jail now, man. These are bogus charges. These charges were placed on me while I was in a holding cell for 12 hours here that was not on me when I was arrested on body cam and no other cam. There was no
Take
drugs pulled
offense
off
and
me
you
at
might say
all.
something today that'll ruin it.
I'm gonna say this, sir, and not be rude, I'm gonna say the same thing I'm saying now that I'm gonna say then. I have done nothing. There was a warrant placed on me for no reason. I'm the wrong person. I was not the person they was looking for. They thought I was someone else, and I'm not.
Okay.
And they ran down on me about a warrant that I do not have. This is a false arrest, man. People reports in the street. This ain't me. They looking for somebody totally different in that same area. This ain't me.
All right.
Ain't none of this mine. Except for
Okay.
resisting arrest.
Well, stop talking.
Okay, I'm done.
Based on your application, I find that you do qualify for the service of the public defender's office. I'm going to appoint the public defender to represent you. Deputy, criminal history.
Missouri 22, tampering with the motor vehicle. Locally 21. Controlled substance, paraphernalia. We're receiving a stolen credit card, trespass, false info. 20 meth, controlled substance, paraphernalia, DWLSR. Locally, it goes back to 98.
All right, man. Introduction of contraband's 10,000. Methamphetamine's 5,000. Paraphernalia is 1,000. Resisting's 2,500. Random UAs. Court date's going to be May 20th at 9 o'clock. Good luck, Mr. Stovall.
All right, step to your right to the T. When the green light come, hold on, come back over. When the green light come on, sign for your copy of it right there. Fred X, sir. State your name. Your name?
Oh, Lonnie Peterson.
Yep, step up on the X.
Mr. Peterson, you're fully court charged possession of methamphetamine and misuse of 911. Do you understand the charges?
Oh, yes, sir, I am.
I understand you've been given copies of paperwork and advice of your rights. Is that true, sir?
Oh, yes, sir, I have.
Based on your application, I find that you do qualify. I'm going to go ahead and appoint the public defender to represent you. Any question about that?
Oh, no, sir.
Deputy, criminal history, Mr. Peterson.
Sir?
Somewhere else in Florida, 22 meth, Possession of meth, smuggling, contraband, DUI. 20 CCW, FTA, 19 battery, criminal mischief, 18 felony bat. Goes back to 14 somewhere else with FTA.
You sound so nit. Somewhere else in Florida. I mean,
It is.
it's like the definition.
Sorry,
Right there.
I am trying to start a new life, but yeah,
But you're still in Florida.
yes, sir. I know. Yeah, I know.
Yeah. All right.
But I'm getting out.
Are you?
I got it. I mean, I know what I need to do. I was just going somewhere to.
Don't
with
help
a
'em.
friend of mine.
Don't help them today. Don't talk about your.
I was
case.
going to get it. I was going to get up with a friend.
He's encouraging you not to talk about any fact of your case, okay?
Well,
All right,
really,
buddy.
I'm not an addict. You know, almost. I ain't gonna say I'm. You know, I'm not a person that. But I ain't gonna talk down on no one. No one's better than the other. But you know, I just. It is what it is.
All right. On the possession of methamphetamine, bond is set at 5,000. On the misuse of 911, 1,000. Your court date's going to be May the 20th at 9 o'clock. Submit the random UAs directed by the court. If you're not an addict, we'll know, won't we?
Oh yes, sir. Yeah.
Okay. All right. Good luck.
Yeah.
Step to your right to the T.
State your name.
Ms. Bailey, before the court charged domestic violence, battery by strangulation, cruelty toward a child, domestic violence, battery, cruelty toward a child with aggravated child abuse, domestic battery, cruelty toward a child, domestic violence, battery. You understand the charges?
Yes.
I think you've been given copies of paperwork and advised of your rights. Is that true?
Yes.
All right. Based on your applications, you do qualify for the service of the public defender's office, and I'm going to go ahead and the public defender represents you. Any question about that?
No question.
Deputy.
Just a DUI and 21 in Georgia.
Bond set at 15,000 on the domestic violence battery by strangulation, 15,000 on the cruelty to child, 2,500 on the domestic violence battery, 15,000 on the cruelty towards child, 2,500 on the domestic violence battery, 15,000 on the cruelty to child, 2,500 on the domestic violence battery. No contact directly, indirectly, or through a third party alleged victims. No alcohol while you're on release.
What day, sir?
It's going to be May 20th at 9 o'clock.
Thank you, sir. Step to your right, ma'am. Red X, ma'am. Face the TV. State your name.
Ma'am, before the court charged aggravated assault and cruelty toward child. Do you understand the charges?
I do.
I'm seeing you've been given copies of paperwork and advised of your rights. Is that true?
Got a copy of your paperwork?
Yes, sir.
All right, ma'am. Based on your application, you didn't complete the application so we can determine if you qualify for a public defender, but the law recognizes you can reapply later. You also have the option of hiring your own attorney or represent yourself. Any question about these options?
No, sir.
Deputy, criminal history?
13, there's a battery and an aggravated assault.
Bond set at 10,000 aggravated assault, 15,000 on the child abuse, Court date's gonna be April the 25th at 9 o'clock. No contact directly, indirectly, or through a third party with any of the victims.
Step to your right to the T. Red X. Red X. State your name.
Julie.
Ma'am, before the court on a violation of probation for was originally leaving the scene of an accident involving death. You understand that, ma'am?
I understand.
Been held without bond. Your court date's gonna be May 15th at 9 o'clock. Good luck.
4 days till what? I didn't understand.
Your court date's May 15th.
I have a court date on the 9th. For
your
the
new
same
charge.
charge.
Not for the same charge.
Okay. Judge. I've seen you before, I think, right?
Yeah.
Yeah. He has trying to set me up for major failure. I wasn't even there.
Okay, well. We'll
Can
sort
we
all
do
that out
it
later. We're gonna sort all that out later. Right now, the problem is you're on probation for leaving the scene of an accident involving death.
Yes, I've done that time. All I do is I use the money.
You're still on probation for it. You're still supposed to do that time.
Okay, well. He has my debit card, my phone, everything that I was going to pay you with. And then he did this. He stole my debit card, stole my phone, and he called. I think he even beat himself up because I didn't do it. It's just I wasn't even there.
Okay, well, again, we'll sort all that out later.
Have bond.
I gave you a
On
bond.
I have a bond on another charge, the same thing.
Yeah, you got a bond on the other charge.
Yeah, can I have one on this
No.
one? Thank you, sir.
Red X. Face the TV, state your name.
Sir, you're fully court on a false ID to a law enforcement agency. Do you understand that charge?
I don't understand if it's a misdemeanor or what.
It's a misdemeanor.
Okay.
Basically,
I also wanted
resisting.
Sir, I also wanted to tell you this social security number on here that they're putting on here is not. I told them my correct social security number. You put the wrong thing on here though.
Okay, well, I mean, here's the bigger problem for you. They got a warrant for you from out of state, right?
Oh yeah, they're not coming to get me.
Okay, good.
I've already been arrested 3 times on it, sir.
I'd get it cleared up, so I wouldn't keep getting arrested on it.
I can't. They get the first time they arrested me, they gave my identification away to some girl, which is I thought was illegal to give somebody's identification away. If it's not their family member, you're giving it to.
So
They gave my whole wallet and everything away.
Are you not on parole violation?
Yes, I'm on parole violation. That's what I'm saying. I can't even get back to Arkansas.
Arkansas not
I
going to
can't
get
get
you.
back. No, sir, they will not because I've already been arrested twice in Mobile. Mobile's held me 21 days 2 times, and then Baldwin County held me one time for 7 days, and they didn't come any of the times. They didn't even respond to them.
All right. Well, I'm going to set a monetary bond of $1,000 on your new charge. Your court date's April 5th at 8:30.
All right. Yes, sir.
Step to your right to the T. Red X, sir. State your name.
Christopher Griggs.
Mr. Griggs, before the court for trespass at the Gold Nugget. You understand that, sir?
Yeah.
We had a run. There was a run of things at the Gold Nugget last night. Horrible. They were kicking people out left and right. What was going on? Were y'all not tipping? Come on, man. You got to tip. All right, bro. I understand you've been given copies of paperwork and advised of your rights. Is that true?
Got a copy of your paperwork? Were you advised of your rights today? Were you advised of your rights today and given a copy of your paperwork?
Based on your application, I find that you do qualify for the service of the public defender's office. I'm going to go ahead and appoint the public defender to represent you. So you have an attorney now. Any question about that? Deputy, criminal history?
You have Ohio and Tennessee, but nothing since 17, and that was a criminal mischief and domestic with a DUI in 16.
What brings you down here from Murfreesboro?
Just to come see my mama. She retired and bought a home here, and I'm just coming down here to try to look out for her for about a week.
Well, why the hell are you at the Nugget?
I'm tired of being in the house and looking at the walls. I want to get out and
yeah, the walls are better looking than what's at the Nugget, though. Come on, man. Golly Moses. Yeah, she is not in school, man. She's not trying to stay in school. I don't know what she told you, but she is not up there dancing for tuition. Okay, bro. You gonna be in court Friday?
Yeah.
You know all the guys on the back row were boyfriends, right? It's all starting to make sense now, isn't it? All right. I'm going to release you on your unrecognizance. Show up in court Friday,
yes, sir.
April the 5th at 8:30. Don't go back to the Nugget. That's just good advice. Don't go back to the Nugget.
Wait. Step to your right to the T. When that green light comes on, son.
I selectively chose that case for the end of the Vann set. Yes, I actually did. All right. We have us an angry lady for the last case of the day. It's from Cowlitz County. It's Commissioner Karm. She's great. I watched about half of this and I've enjoyed every second of it that I've watched so far. So let me present you with this golden nugget for our last hearing of the day. Thank everybody for coming out. The comments have been hilarious. Keep them coming. I'm loving this commentary. And we'll get right to Cowlitz County right now.
Okay. And then in iPad booth 1, are you Sandy Morris?
Yes, ma'am.
Okay. So let me now go back to Ms. Baldwin and Ms. May Brown's matter on S&D Tecum LLC v. Sandy Morris. She is there in iPad booth 1. This is 242-0017408. I'll first hear from Ms. Baldwin how the landlord is asking to proceed today. And I will let the parties know that I did receive the documents in this matter and have had a chance to review them.
Thank you, Your Honor. We are asking to proceed today. I'll just note that in this case, opposing counsel entered a notice of appearance on March 8th. True to form, opposing counsel, as I believe is a strategic matter, did not respond until yesterday, essentially almost a month later. It's truly strategic in waiting until the day before to file their answer. This is something that is consistently done. And when it's one thing when representation is coming on board, at the last minute, that's not what happened in this case. So again, that's strategic and the court should view it as such. In this case, it's very clear, and there's essentially an admission by the part of the defendant as to the damage that they have done to the unit. There's a sworn statement that she submitted in a prior legal action that there's more than $6,000 of damage to the unit. We do have declarations from multiple individuals that are not just essentially maintenance workers, but others that are also verifying the damages to the unit. And in this case, there is a cure period my client has to deal with that cure period where they're allowed to continue to live there, allowed to continue to reside as a full tenant with the full rights, and all of those things. But where we stand today is we're still in a position where the defendant will not make the repairs themselves. They will not allow my client to make the repairs. They essentially want to demand a specific repair agency make those repairs, and it's for damages that the defendant has done to the unit. My client is not financially responsible for those damages. So they're not actually obligated to make that repair. The tenant is. If the tenant causes damage, they are obligated to make the repair. My client's already repaired it. I think at this point, the testimony is twice. And the indications are that the tenant is causing this damage. At this point, my client's done everything they can do. They've really bent over backwards for this tenant, trying to assist them, but we're in a position where the unit is continuing to be damaged. We are asking for a writ at this point, given the fact that we have a long-term history of someone who's not allowing anyone to access the unit, not allowing repairs to be made, and because this is water damage, it's gray and black water, which isn't denied. And so that's a significant concern. All the cabinetry that's involved. So it's not just the plumbing, it's all the cabinetry that surrounds that's getting damaged and likely will have to be removed. So, I mean, 6,000 is really the minimum amount of damage, but even the defendant here acknowledges that level of damage. So in this case, we are asking for a writ because her own sworn statement acknowledges the damage. We really are in a position where she can't deny that. And because of that, the court should issue the writ, allow this case, allow for us to get a date with the sheriff. At this point, that is appropriate in this case, especially with all of the additional declarations that we have in this file that sort of verify the long history of my client's attempts to work with this tenant to remedy the situation.
And I just want to, Ms. Baldwin, just a quick question. I think I know the answer, but I want to make sure that I'm understanding the landlord's position. I saw in the recently filed, as you note, a brief from a tenant's attorney that they're alleging that rent was accepted, so therefore this matter can't move forward. I understand your request to be, at this point, somewhat exclusively based on waste and damage. Is that correct?
Yeah, so the underlying is, although this is a 30-day, it's a 30-day because this would traditionally be a 3-day type of situation. It's a 30-day because of the underlying housing situation. There is a required cure period. So this is unique in the type of housing. My client is accepted rent because there's this cure period where they'd have to accept because the person has the right to cure during this period. Even the notice itself says you can cure. Had the tenant made the repairs, allowed an inspection, arguably she could have cured during this period. So my client has to accept rent. It doesn't really have the option to not accept rent. If a rent was accepted, for example, in the last bit, which can happen periodically because somebody has sent rent in and it's like it's in the mail, or my client hasn't turned the check around yet. Some folks have situations where they can deposit it directly in my client's bank account. And so it can take time for my clients to kick that back to them, saying hey, no, we're not actually accepting that. Then that's sort of the situation that we would be in here, where it just simply hasn't had the opportunity to kick that back around just because of the timing of this case. We're at the beginning of the month of April. So again, not a situation where that would be applicable in this case.
Thank you. All right, Ms. May Brown, go ahead with your request of the court or argument you would like to make.
Yes, good morning, Your Honor. To start with, I would address plaintiff's grievance with our submitting defenses last night. They first off were submitted only shortly after plaintiffs submitted their declarations. Tenants are allowed by statute to present defenses either in writing or orally as quickly as soon, as close to the hearing as at the time of the hearing. So us submitting them prior is a good faith showing that we wanted the court to be able to review these defenses beforehand and to show plaintiff as well what we had. However, I will say, to answer the question about the acceptance of rent, Your Honor, it is well settled law that when a landlord accepts rent after a breach of the lease, they have waived their right to maintain an unlawful detainer action for said breach. This includes acceptance of rent after a 3-day notice to quit, or more commonly, after a 10-day notice to comply or vacate. What this matter seems to be, more to me, at least the notice that was served, was in effect a 30-day notice to comply or vacate. So acceptance of rent after the service of the notice is a waiver. So acceptance of rent during that comply period. Furthermore, as we have provided checks showing that rent was proffered and no evidence has been shown that rent has been rejected after the compliance period ended. So furthermore, alternatively, so for that reason, because of that waiver, we would request this matter be dismissed with prejudice. Alternatively, Your Honor, though, we would request this matter be set for trial due to defendant contesting plaintiff's statement that they caused the damage to the property.
Anything else, Ms. May Brown?
No, Your Honor.
Okay. Ms. Baldwin, anything in rebuttal?
Yes, so the law here has actually really changed. If we were to go back, a lot of the case law that you should be looking at is really based on the old 3-day pay or vacate situation. Under sort of that body of law, you used to be able to, hey, 3 days pay or vacate, and if they didn't pay within those 3 days, you could say, hey, even if you're trying to pay now, I can refuse to accept the rent. But if you then accepted the rent, you couldn't then continue your eviction. That makes perfect sense. But the law here has very much changed. So counsel now would argue that, hey, if you do a 10-day, well, then if you accept rent, you can never move forward with an eviction. But we know this isn't true because, for example, if you're going to do an eviction based on 4 10-day notices and a 60-day notice, the landlord doesn't have to not accept rent for a 100-day period. That would be waiving rent or essentially refusing to accept rent for 3 entire months, saying, oh, no, I refuse to accept any rent, even though you've cured, even though you resolved that situation, I'm just not going to accept rent so that I could do the eviction. It's just, it stops being logical and it stops being statutorily supported. So now, because the law has changed here, it's no longer statutorily supported and it's no longer, frankly, even logical. So in this case, it's no longer logical, and we have a case where there's very clear evidence as to the damages and very clear evidence as to my client's attempts to resolve these damages. In this case, it's very much appropriate to issue the writ.
So here's my ruling. I have reviewed some of the case law cited. I've reviewed the declaration of Sandy Morris. I've reviewed the declaration of Jim Armstrong, Larry Flanagan, Shelley Watkins, Jim Brockway. I don't think I'm missing any, but those are the ones I printed off. But I've also gone back and looked at the complaint and the original 30-day notice. So first, in dealing with whether acceptance of rent precludes this action moving forward, I agree with landlord in this matter. In essence, the case law I've looked at dealing with 3-day and 10-day notices makes sense, right? Those are short periods of time. We're asking, in mostly, not all cases dealing with failure to pay rent, but mostly dealing with failure to pay rent. And of course, if that's the dispute and the landlord accepts rent, why would we let you come to court and pursue the matter further? This is a 30-day notice because of multiple unique factors in this case. This is a 30-day notice where the allegations, specifically, the notice shows no past due rent. So rent is not an issue in this case. What is an issue is significant allegations of waste, nuisance, and damage. So number one, under this specific fact scenario and a 30-day notice, I do not find that the case law supports that this action must be dismissed,
Your Honor,
as a payment of rent.
My apologies to interrupt. I would ask if you could also rule on the fact that rent was accepted after the unlawful detainer was also filed, because there is case law that states that if rent is accepted after the unlawful detainer is also filed, that is a full stop waiver as well.
So I'd ask the owner not make any ruling about that. Again, this is where the 11th hour filing does directly prejudice my client.
Yeah, I agree. And I'm gonna continue with my ruling. If you have additional matters you want to bring up, let me finish my ruling, Ms. May Brown. I will come back to you. So let me get back to where I was. First of all, again, just to reiterate, I am not finding that this action should be dismissed because of acceptance of rent under these factual scenarios. I'm going to move to whether I believe this should be set for trial based on any material facts. And I'm going to, by analogy, pull from essentially civil summary judgment. Hold on, folks, please mute. In a civil summary judgment standard, a non-moving party can't create disputed facts simply by filing self-serving declarations and affidavits. That's essentially what I find here. I find that there's a wealth of evidence that this waste and nuisance and damage has occurred, and that the tenant has created it by her own admission to some degree. And that she has failed to allow the landlord to come into the premises to fix this. This is stated not just by way of the landlord's declarations himself, but by others. So I don't believe that there's any material issue of fact, but for the tenant essentially denying the allegations. And again, I view that as a self-serving affidavit in this regard. I don't think that it overcomes the amount of evidence to the contrary, and I don't believe that that would warrant a trial in this case. I am going to issue the writ, the order for writ today. Hold on, please. I'm not done, ma'am. Do we have an order? Okay. I know this, I believe this case has been set over a few times, so we don't have an original order here. Ms. Baldwin, if your office wants to send one over by email, I can get that signed.
We will do that, Your Honor.
Okay. My apologies, Your Honor. And I'm so sorry.
I
thought you were done with your ruling.
I am going to open it up for questions and comments here in just a minute. Let me just get through what I need to say. So Ms. Baldwin, if your office wants to send that over with copies to all parties, to Sylvia Workala, my judicial assistant, I will get that signed when it comes in. All right, Ms. May Brown, go ahead.
Yes, my apologies, Your Honor. I thought you were finished. I would ask Your Honor if you could please also rule on the specific language of case law that states a tenant's testimony specifically disputing the breach of the lease creates an issue of material fact warranting trial, according to Webster v. Litz and Housing Authority v. Pleasant from 2005.
I'm happy to rule on that. I think that it is, I think I did rule on it, stating that I think the tenant's own declaration, number one, is self-serving is disputed by many subsequent affidavits. And in order for me to find that there's a material issue of fact, I would have to find that there's some logical basis for what is being stated in the declaration. I do not find that. Anything else I can address for the parties?
Yes.
Not at this time.
Okay. Your Honor, I believe my client would like to testify briefly if she can be allowed to state something on the record.
I'm not going to take testimony after my ruling, but Ms. Morris, do you have a question for the court?
Yes, I do.
Okay, go ahead.
Excuse me. My question is this. Is it, I'm trying to form it correctly because I don't want to say something wrong. Is it typical for the court to not permit a defendant to put on a defense? This is when they refiled this case. So this is the first time we've had a hearing. So it wasn't ever set over for anything as far as I knew. Also, is in the court's position that the plaintiff can do a Hail Mary last minute of sending multiple declarations that the defendant has not even had an opportunity to address because they in fact sent it over just the day before yesterday. So it wasn't even sent to the defendant to be able to respond. Is it the court's position that when a case law changes, when the law changes in one state or etc., and this one I happen to know the actual answer to, that other case laws or other laws do not apply? Because according to what I understood, so I want to understand, does this court not recognize that if a law is on the book, are you saying that that law, even though valid and on the books, no matter how old it is, no matter what the new law is, if it's still on the book, is your position that that law is invalid, even though it is valid on the books, even if it goes back to 1776? If it hasn't been abolished, it's a valid law. So I'm kind of curious because when Miss Baldwin spoke about a tactic of not coming in on time, etc., I find it odd that the court would be okay with the tactic of stating of a, not just an attorney, but a commissioner herself. So she's held to higher ethics altogether. And as an officer of the court, she's not supposed to lie. So I'm curious, where is it? Because the court has not addressed this. Where is it that I have that the defendant would have ever stated if there was no position for the defendant to address no time for the defendant to respond to a plaintiff's multiple declarations, and then the defendant can only respond when they get one, not 5 or 6 or 7, just the one. So that's what they could focus on. Not, like I said, don't know what the 5 or 6 some other ones. So is the defendant supposed to sit there and say, wow, when there's laws on the book, you're dismissing it for what purpose? Just because they're new laws. But the law reads that if the laws are on the book, they're still valid, no matter if new laws were created. I know that. Also, to say that a defendant takes responsibility for something, can she provide evidence of that? Because simply to say something as a position of a commissioner and an attorney herself, so again, officers of the court, you cannot lie to the courts. Where exactly does this position come from? Because when a defendant is presenting as much evidence as they can to not even one declaration, but just that they have facts, they have pictures, they have videos, they have phone calls, and the court is like, we're just going to listen to a commissioner.
No, ma'am, I'm gonna hold on. No, I'm gonna pause you there. I've given you a lot of leeway here. Ms. Morris, you have been represented by an attorney since March 12th of 2024.
I was?
Yep.
Oh, I did not know that.
They filed a notice of appearance on your behalf, actually dated March 8, 2024. So essentially 30 days you have been represented by an attorney. Hold on, ma'am. Their notice of appearance was filed with this court March 12th, 2024. So the questions that you have presented to me regarding presentation of evidence would be more properly directed at your assigned counsel, since they have represented you now essentially for a 30-day period. I'm going to go ahead and end this matter. The case is...
Wait a minute.
Ms. Morris. So I will give you a call after this. to
I'm
talk to
curious.
you.
Ms. Morris, Ms. Morris,
Give the documents until the day
Ms.
before.
Morris,
Ms. Morris, you are represented by an attorney. Please direct your questions to them. I do appreciate you being here today. I'm going to go ahead and conclude number 3 on our docket. Thank you all. You're free to log out.
Thank you all. You're free to log out. That's it. That's all we got. I hope it's enough. It's been fun. It's been a Saturday. It's been a good weekend morning brunch set of court cases. I really enjoyed that Vann block. That was fun to put together. I hope everybody's enjoyed the set of cases I found and put together for us this morning. We'll be back same wolf time, same wolf channel next week. Join us then, and I'll see you there.
Like